Good morning, everyone, and we have to apologize for the delay of the uploading of this video for some health reasons, and that caused the delay of the recording. But in the future, we endeavor to be prompt, and especially that. Also, I have to apologize before I forget that I'm doing the recording in my office, and my office is next to the highway, so there could be some noise in my background. I apologize for that. Now, today's lesson is about the salient points of the revised rules of civil procedure, and it was duly announced in our lesson plan last Sunday. However, I want to focus on today's lesson on the revised rules of um, civil procedure, especially on rule number 7. So, in the future lessons, we will be tackling each specific or rule of the new rules. Now, the said rules took effect on May 1, 2020 of this year. So actually, it was during the pandemic, and I think there are practitioners who failed to read the rules, and it's not impossible also that there could be the new provisions could be missed out or not complied with in the filing of pleadings or documents before the court. Now, this lesson is very relevant to those taking up their remedial law classes, and for those who are practitioners or those who are interested in litigation in the legal practice. Now, the set rules is applicable to those cases filed after May 1, 2020, and those cases already pending before the court, except those um, if the court sees that the application becomes or it's not feasible to apply or to comply the same, and it would also work in justice. And you have to take note, if you looked at, I would really advise that you have to read the full text of the new rules. And if you notice, it is obviously gender sensitive to the point that you can see the words his or her. There's a specification. Now, Rule 7 is on parts and contents of a pleading. Now, the new rules specify that the signature of counsel constitutes a certificate that he has read the pleading and document, and it is to the best of his or her knowledge, information, and belief formed after an inquiry under the reasonable circumstances. Now, it's like a party signing a verification. Now, in Section 3, Paragraph B of Rule 7, it says that there should be the pleading or document is not being presented for improper purpose, for example, to harass or cause unnecessary delay or needlessly increase the cost of litigation. So actually, this is related to the fact that the signature of counsel constitutes a certificate. So aside from that the pleading or document is not filed to harass or cause unnecessary delay or needlessly increase the cost of litigation, it is the claims, defenses, and other legal contentions are warranted by law or jurisprudence or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. So this is what the lawyer is certifying to. And aside from that, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after availment of discovery, like modes of discovery. So it's provided actually in the old rules, the modes of discovery. Now, lastly, the denials of factual contentions are warranted on the evidence, or if specifically so identified, I'm sorry again for the noise, are reasonably based on belief or lack of information. So these four things are actually the um, the certifications of the lawyer. Now, in case of violation of these four, there is a disciplinary action on an attorney, a law firm, or sorry for the misspelling, the party that violated the rule or is responsible for the violation. Now, you have to take note of the joint and several liability of the partner, associate, or employee. Now, what are the sanctions? Sanctions could be non-monetary or monetary, and monetary sanctions could be the attorney's fees and other expenses. And it cannot be passed on to the client. So it's only the lawyer, the law firm, or other persons responsible. Now, what about Section 4? The rules require additional attestations on the verification. So we know that we file, example, a complaint, then there is a verification and certification against forum shopping. Now, the new rules provide or requires additional attestations, and there are three, or I mean two actually. First, the pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation, just like the certification of the lawyer. And the factual allegations therein have evidentiary support, or if specifically so identified, will likewise have evidentiary support during or after modes of discovery were availed. Now, what about the special power of attorney and the secretary's certificate if one is authorized to sign the pleading? Section 5 of the new rules provide that the authorization of the affiant to act on behalf of a party, whether it could be a certificate or secretary certificate or a special power of attorney, it should be attached to the pleading. And lastly, the rules provide that the pleading must contain the names of witnesses who will be presented to prove a party's claim or defense, and the summary of the witnesses' intended testimony, and also the documentary and object evidence in support of the allegations contained in the pleading. So basically, at the onset of the litigation or the complaint, the parties are to lay down all the pieces of evidence against the other party. So we are taught to lay down all your cards and nothing would be hidden. So thank you so much for listening for this very quick lesson on the new rules of civil procedure. And please don't forget to follow our video lessons through our Facebook page and also our YouTube account. Thank you for the more than 1,000 subscribers. And please don't forget to click on the notification bell so that you will be notified of the new uploaded videos. And also our website, actually I'm working on it. It's just that I'm so busy because hearings are has assumed, except for those out of Cebu hearings I could not attend. So thank you so much. Thank you.